Yes.
Lord Lady, the first thing I wanted to pick up on is a point of housekeeping that you raised with us right at the beginning, and that letter.
Yes.
Yes, it was actually us writing in to draw attention to something that Apple had pointed out to us. There was some confusion about whether it was as to why the redacted version goes on the portal. They've actually had the letter. It's just a point of clarification. So it's agreed that you should read it. It's not a major point, but I think something went wrong with the fact that it was alleged that something in it was confidential, so the portal got the wrong version. The next topic that I'm moving to is looking at the Court of Appeal methodology itself, and I'm going to take this as briefly as I can. And the first point, what I'm going to, is to pick up a point that we've been debating, and just to draw attention to 120 of the Court of Appeal judgment, specifically identifies that paragraph 417 little 3 as infected by this illegitimate point. So it's not the methodology itself, but it's a point that I didn't specifically draw to your attention when...
Sorry, which paragraph was it?
It's 120 of the Court of Appeal on page 307,
yeah. And
it's dealing with the legitimate point, and basically Lord Justice Burst is obviously taking the same view that I was submitting to my Lords and my Lady. That brings me to just outline as briefly as I can the key aspects of the Court of Appeal's methodology. So obviously this is its own methodology applied to replace the judges having concluded the judge went wrong. And at a high level, what my Lords and my Lady will have picked up is that they used the comparables not to identify a particular price, but to identify a window. The comparables were used to identify a window, so that's step one. Step two, the window gets narrowed from the top, and that is use of a finding of fact. And then the Court of Appeal judgment exercises judgment to evaluate where in the window the FRAND answer is, and they use conventional top-down reasoning to do that. So that's the big picture. And I apprehend that the real issue that my Lords and my Lady might be concerned about is, at least to start with, the identification of the window, and in particular the extent to which the Google license was used in that step. And the key part of the judgment for that is paragraph 137, where Lord Justice Burst starts to draw his conclusions. And my Lords and my Lady should note that 137 actually has two limbs to it. The first is the second sentence, and that's looking at those highest four Apple licenses. It shows that a DPU rate for Optis lower than those implied by Ericsson, Interdigital, Nokia and Cisfel would be too low. And that's obviously a conclusion building upon the earlier finding of holdout being present in the Apple licenses as a whole that had just been made at the foot of page 307 just before. And that earlier finding was deliberately qualitative, but the obvious point, once the judge had put those on a scale representing Optis, for those four licenses, they're too low. And the second limb of 137 is in the third and fourth sentences, which draws attention to the judge's conclusion when expressed as a DPU and saying that there's no justification for that. And it's obviously the first limb that really matters for my Lords and my Lady. It's an obvious conclusion that flows from the finding of hold out, and it cannot seriously be suggested that it wasn't open to Lord Justice Burst as part of his evaluation exercise. Now, the next paras 138 and 139, he has regard to the Google rate, and the effect of those paragraphs is basically to look across both Google and the highest Apple holdout licenses and take each of them as indicating the other is too high or too low, respectively. And I've already made my submissions about the legitimacy of that exercise and that both courts below did it. But I also draw attention to the fact that it's not necessary. He's already concluded that the 4 Apple licenses are too low by reliance on the obvious holdout conclusion at the beginning of 137. And as I've said, that can't be faulted. And Apple obviously aren't worried about the conclusion that Google's too high in these paragraphs, but just so that my lords and my lady are satisfied intellectually with the submission, on Google, he also relies upon the 15% total stack cross-check as a further reason for Google being too high. That's para 140. So in summary, there are 2 separate reasons for each conclusion at the bounds. 138 and 139 together, the conclusion of them in the looking at them in the round applies to both bounds. But if you're worried about that, it doesn't actually matter because there's a separate conclusion for each bound. You've got the 140 reason for Google, and you've got the first limb of paragraph 137 for Apple.
Well, I am personally worried about it because I don't see how you can rely on 2 unreliable estimates to discredit the other. The most you can draw from them is a top and a bottom. Well,
that's all he did do, in fact. But what
it's not all he did in his reasoning, because he said that the Google license shows that relying on the Apple licenses would produce a rate that was too low, and you can't conclude that just from the license that is too high.
Sorry, I thought you meant all he did is use them as too high and too low for the window, but
no,
I misunderstood, my lord. The point that I'm making to my lords, to my lord and my lady, is a broader point that I understand the worry, the logic.
You're saying if we cut out those 2 paragraphs, it wouldn't make any difference.
I'm saying there are 2 reasons for both of the bounds, and it doesn't matter. Both of the courts below did that. My submissions I've made already is that it's legitimate, but I certainly don't want to take up time to repeat them. No. I'm saying to you it doesn't matter because there are other reasons for each.
Well, 137 wouldn't be a reason for going higher than those 4 companies, would it? Because in itself, he's simply saying, in 137, I can see no justification for a rate as low as that which the judge arrived at when those 4 companies are able to license Apple at an appreciably higher rate. So his conclusion in 137 appears to be primarily, it's obviously against the background of everything else that's gone before, but it is primarily based upon the comparison between the DPU rate for those 4 companies and that arrived at by the judge.
It's the second sentence, my lord. The guts of the second sentence is that they're too low, those licenses.
Of course. Well, lower than the rates implied by those rates would be too low.
My submission is the substance of that. I understand there's a kind of argument that he hasn't actually said bang on those 2 licenses isn't too low, but the substance of it is he's relying upon them all as having been subject to holdout, and so the substance of it is he's identifying those as too low. Yeah. I understand the linguistic point that my lord is putting to me, that you haven't dealt with precisely bang on them, but the substance of what he's identifying is that they are too low.
Yeah.
Now, the stepwise narrowing of the window, i.e. identifying within which FRAND will be found, is again something which we say is an evaluation, and it can't be said that there's an error in doing that. Identifying a range in which FRAND lies and then narrowing it is a conclusion that is open to somebody that evaluates where FRAND is in my submission. And the upshot is that Lord Justice Burse exercises judgment as to where to go in that. And part of that evaluation might have been picking one of the boundaries and itself looking to see if you can adjust it up or down. So one of the things that you might do when you've identified a window is that, or you might identify what realistic possibilities there may be in the window and assess them individually. And either would be within the realms of what you're entitled to do as a decision maker. And if you do that latter one, also identifying what the realistic possibilities are as a matter of that you're going to look at is a matter for the decision maker to evaluate, including how far they're spaced. So that, in a nutshell, is what he did do, and you know that the way he did resolve it was to look at the realistic possibilities, and he rejected the one, the lowest one, very quickly for a reason which is confidential, so I can't read it out. But insofar as it relates to Apple, my submission is that that was plainly open to him. That's part of the evaluation, and is in fact really probably the point that my Lord was just putting to me as to precisely...
Which paragraph are you referring to at the moment?
143.
Okay.
And it's the highlighted bit right at the last 6 words. And again, that's a matter of evaluation in the light of his conclusion as to the effect of holdout.
I can understand the reasoning in the highlighted words. I can't understand because it's too far from Google.
I understand that as well, and there are 2 separate reasons, and my lords and my lady only have to be satisfied with one, and I think it is exactly the same.
Well, I'm not too sure, because there's a difference between saying just relying on one reason and getting to the conclusion through thinking that the first reason also has force.
Well, it's the same point, I think, my Lord, that you've already been putting to me. So my submission would be the same, that it's legitimate, but I don't want to take up time repeating the submission, because I think it is exactly the same point. And my submission is that the highlighted one is enough in itself, particularly if you do understand that his conclusion is that the totality of the Apple licences have been affected by a holdout.
That must be the inference.
Yes, exactly. It is. And that's, my friend complains that that's his conclusion. So that's all I really wanted to say about the methodology.
Well, there's a couple of other points, though, that were made against you. One is the use of the 470, the use of the Google phone price as a measure, which doesn't seem to have any logic to it, and the fact that he didn't look into the kind of measures of phone price that had been discussed or analysed at the trial. And the other point is that he relied on being entitled to the top of the range, which it said is inappropriate methodology. So those are 2 other points that need to address.
Yes, certainly I think those are in the points of attacking the method. I was just trying to explain what was going on.
Oh, sorry, I thought you were saying that was all you were saying about the method.
Sorry, all I wanted you to explain it.
Okay.
You're absolutely right that I've got to deal with that. And in fact, can I move on to deal with what's left of ground 1A? I have dealt with quite a lot of the points in ground 1 already. Ground 1A is basically answered by the following, insofar as I haven't already dealt with it. It's not an error to identify the better comparables, and this is also not a case where averaging is tenable. There is a further point that I answer in relation to the specifics of the Mr. Bazant evidence. It's not supportive of averaging as the way my friend suggests. It's about looking at a broader range of licences to pick the best, and the second transcript is actually about an iterative exclusion method of excluding licences when you're looking at a particular point on past-future split. So in my submission, there isn't anything in that either. I think broadly on 1A I've answered everything else. I've gone along and explained, for instance, why averaging can't be a tenable approach. The next one is ground 1C, and that's a complaint about looking at the Apple licences as too low and the Google licence as too high. Holdout is obviously the answer for the Apple stuff. As regards the use of the Google licence, my friend has to tread a bit of a careful path, because the judge concluded it was evidentially significant, and we give you all the references in paragraph 91, page 128, as relation to that. And it's not used as a close parallel. As I've just been highlighting, it's been used in a way to identify an area above which FRAND can't be found, and that also that window is then further narrowed in any event by looking at the finding about 15%. The upshot, my lords and my lady, none of this is an error, and it would be a surprise for my lords and my lady to say that in cases where licences aren't capable of being used as very close parallels, they can't be used in an evaluation to exclude that which is not FRAND, and that's what's going on here. A core part of my submission is you can't just have a submission about whether you can or can't use a licence without knowing what's the use that's being made of it. You've got to look at the use. The next ground is ground 1D, and that's the top of the range point, the point that my Lord Legate just put to me. Apple suggests this is some benefit of the doubt thing. It's not, and it's entirely conventional to view FRAND as not a precise thing. So this is not saying anything about what you do because of uncertainty. Of course you do the best you can to identify the thing you're searching for, and that might mean going for the middle of a band of uncertainty, assuming that there's an equal spread. This point is about identifying the thing you are searching for. FRAND is typically referred to as a corridor or a range, meaning that it's not one precise thing. And, in fact, I think my Lord Legate recognised that if there was a case where there was an offer made and the question was, is it reasonable, the court may conclude it is, even though something lower is. Now, if that's true, that higher thing is reasonable, even if that offer hadn't have been made. And the conventional analysis is FRAND is a corridor, and you only have to offer something in the corridor. And so the court takes account of the fact that it's looking for something in the corridor that the patentee is entitled to offer. So it's nothing to do with uncertainty. It's to do with the fact that the thing you're looking for is the higher part of the range that the patentee is entitled to offer. That's all it is.
Is that what you're looking for? Or in a situation where you're not reviewing whether an offer is FRAND, are you simply doing the valuation exercise as the court?
No, my submission is the authority I showed you, you take account of the fact that the patentee is entitled to offer the more advantageous of what's in the corridor. Nobody's suggesting this is a massive corridor, but you just take account of the fact that, for instance, it's not an answer for someone to come along and say, but X minus a little bit is also reasonable, so we should have that. That's all it is. You're just taking account of the fact that the thing that you're being asked to look for is what is it that the patentee has to offer. That's it.
The Court of Appeal clearly took the view they had to arrive at a figure.
Yeah, you have to arrive at a figure. All I'm saying is that the thing that you're looking at for is something which is in the corridor, but not in the middle of the corridor, at the more advantageous range that the patentee is entitled to offer. It's a very small point because nobody suggests this is a massive range, but it is an identification of the thing you're looking for point, not an uncertainty point. And you can test it by the example that you gave me, my Lord, because if you think to yourself, is that higher thing reasonable, even though the offer hasn't been made? Of course it is. Would they be able to discharge their obligation now by offering it? Of course they could. So what is the answer that you should come to if you're the adjudicator? It's identifying what they are entitled to offer. And that's why the example you gave actually helps. The second point on this is the 5 cents point, and they're too far apart. I've already foreshadowed the answer to that. If you choose to identify realistic possibilities to test them, it is a matter of evaluation for the decision maker as to what they are and how far they're spaced apart, and it can't be criticised in this case, certainly not on the basis of the sales numbers are a lot. The answer, the reasonable possibilities are the same, whether it was a tiny implementer or a big one.
Well, that may not be right. If you're dealing with vast sales where each increment produces a very large lump sum, then it may be much closer attention will be paid to how large the increments may permissibly be.
Well, my lord, not so when the reality is what you're doing is picking something which is basically a decision as to how precise can you actually be with this exercise. That's my submission as to what you're doing. And it's not possible to be more precise because you've got bigger sales. And that's what's being done. And I don't think they're suggesting that it is a way to do it. There is a way of being more precise, and certainly not that there's a way that's to be more precise because they sell more. Can I move on to ground 2? And that concerns the aggregate stack. And there are two quite separate points here. One is the argument that you have to assess what is a reasonable overall stack by reference to a cheap phone. I'm not sure whether my friend's seeking to rely upon other products like the Tunstall panic button, but the answer there is short and simple. If it's different products, you're obviously going to be looking to see what the value of cellular for those products is, and it'll be completely different. Apple's printed case focuses on cheap handsets and relies upon that paragraph 114 of the court's decision talking about the single price reflecting the value of CEBs. But this silent premise is that it must be $1 per unit. And of course you understand why that has an effect, because if you go to the cheap phone, work out $1 per unit, they're then saying it's the same, and that's why they want to run the point, because it means that they pay the same as somebody where the reasonableness has been assessed on say the $30 phone. Now, we say that that is completely wrong, that analysis, and it assumes that the value of set, i.e. cellular connectivity, is the same across all phones, and we've already covered why that might not be considered to be the same, and how, in fact, the very nature of what they're doing, the top-down cross-check, is in fact an AV assessment at the end of the day. They just want to get you back to a $30 phone, do the AV assessment, forget it was an AV assessment, and now say it's that low DPU price that you pay on an Apple phone. And that fundamental premise of this argument is actually inconsistent with a finding that the judge made that's ignored by my friends because it's inconsistent, and it's in his footnote 300 on page 462.
So which page?
462. Page 462, footnote 300. The judge says average selling price is relevant. Indeed, it's a key factor. Of course, he was working in price being a lump sum, not DPU, but the conclusion that average selling price is a key factor in price is not affected by that confusion. And my submission is that their case on this is just flat contrary to that. Now, Lord Justice Burst carried out the top-down cross-check to choose between two realistic possibilities in the window he'd identified, having rapidly dismissed the lower one. And as I've said already, the result was in fact to pick the lowest possible one in the window. So the first point I make is it's actually hard to complain about how this outcome has caused any problem for Apple. But in any event, what he did was entirely rational and comprehensive in my submission. He dealt with 3 different handset prices, and they were all the ones that were around, or they were related to the products that he'd used to both identify the window and narrow it, and they were 2 Apple prices and the Google price. The Apple cross-check that he did indicated that for Apple, the overall stack was nowhere near being unreasonable. And the other cross-check utilised the Google price. But that, in fact, is generous to Apple because it's using a price that's much lower than Apple's, but still indicated that the total DPU stack price of $40 would not be unreasonable, even at handsets at Google's price. So all three prices he used to give answers don't suggest that there's any issue being an unreasonable overall burden. And my friend seeks to make something of the fact that Mr. Bazant used a lower cap when unpacking Apple licences. And I've already foreshadowed the explanation of the basis for that. There's a difference between what may be a FRAND cap and that which may have occurred in real life, particularly where there's no non-FRAND behaviour. Sorry, not no non-FRAND behaviour, where there is non-FRAND behaviour. The real life thing is an exercise in trying to work out what was likely the way the agreement was struck. And so just in the same way as when you try to work out what the price was for the future and the past, when you know that there's been a discount one way or another, the free release is the extreme version of that unpacking. You're saying, I know that probably very little or anything was given for the past, so you do a free release, and it's the same thing in principle. What you're doing is trying to work out what in fact happened, and that's a totally different thing as to what may in fact be the FRAND way of approaching the number. And so that's the answer to the reliance on what Mr. Bazant was doing for unpacking.
So he was doing it for a different purpose?
He was doing it for unpacking, and he actually explained how he assessed that the best he could as to what was likely to be in the minds of the negotiators. I mean, he had to make certain assumptions and carry stuff across from different negotiations, but it's absolutely plain. He's doing it for a different purpose. It's unpacking. So can I turn now to the second limb of ground 2? And that's quite a different point, where they allege that the Court of Appeal erred in not making the comparison, which they say can be seen from the result of the interdigital case. And that's not a comparison with a number that you can see in the interdigital case itself. And you're aware that they don't want to do the comparison with the Unwired Planet decision, which was available, where Mr. Justice Burse obviously decided a rate for Unwired Planet, but he also approved an overall stack price in his cross-check of 8.8%. I don't ask you to turn it up, but it's paragraph 476 on 3273. They don't want to do that. Instead, they say that you should go to interdigital and you should imply a comparison by mixing and matching doing a calculation by mixing and matching the actual rate for the interdigital portfolio and a finding based upon the enography approach here as to what the interdigital stack is. And the first point I make about this is this was not something that the Court of Appeal was ever asked to take into account. And that's important because at this stage we're asking, is there an error of principle in the way that evaluation was undertaken? And the allegation that they refused or failed to take into account something that was never suggested to be relevant is not a way in which you go about challenging an evaluation. So that's the first point, and it's a sufficient answer in itself. And in fact, although we make that point, my friend didn't actually even deal with that in his oral submissions. I'm slightly worried that that might be one of the several areas where I hear my friend's argument for the first time in reply. It's just not fair or right to suggest the judge erred in principle in an evaluation by not taking something into account that nobody said was relevant. And there are several further points I make. Interdigital itself was a case where a satisfactory top-down check couldn't be carried out. It was part of the case there, but in fact it indicated a number way too low, but the judge decided to stick with the decision because he thought the comparables approach was better. Next point I make is, as I understand what they're really trying to do is to say the essence of this is that a court has approved a $6 DPU price stack, expressed an opinion as to it being reasonable or acceptable, whatever it may be. But no court ever did that. They never did that. That's why we were puzzled as to how they got it. I certainly was. And as I've already explained, the way they've done it is to mix and match findings in this case and the other one. And that is illegitimate. And I'd ask, where would it end? What can we do? We can stitch together conclusions or findings in 3 cases, 4, 10. It's absolutely necessary for them to be taking a decision about one thing in this case and popping it into a calculation. So on another case, where you might need 3 factors to feed into a calculation, you can mix and match 3 cases. What I do draw attention to is that in no case at all were there any parties that were able to actually challenge and deal with the totality, which is obviously what this Hollington rule is all about. The final point I make about this is that this case also, or this argument also suffers because InterDigital was one of those cases where the rate was adjusted down from the comparable that was used in that case, which wasn't Apple, it was another player, because of these market-specific factors. So if you've got a focus on an emerging market, you argue, that's why I explained those at the outset, you argue for it to come down. So it's been bumped down because a lot of the sales are in China or wherever it was, but by these factors that are in play. And then they just want to do the comparison and read it across. Who knows what that adjustment would have been if it had come from Apple, because it was from somebody else. So, my lords, my lady, that's really the end of it in my submission. It's completely inappropriate. We've explained what we understand paragraph 44 and 45 are and how that relates to 44 and 45 of the Court of Appeal judgment and how that relates to Hollington in our case. It's not actually relevant in my submission to how to dispose of this appeal. I wasn't going to take up time dealing with it orally because I think we actually agree the nature of what you're doing when you look at foreign judgments and that you might be able to do that for a domestic one as well. But it's just not appropriate for this comparison. Now, ground 3, can I deal with that very briefly? We deal with this in paragraph 145 and 147. And so we're here assuming that they were right, the Court of Appeal was right to say the judge's decision couldn't stand. We're not talking about the deference that you give to lower courts in deciding whether to interfere. This is a question of whether they should have sent it back for a retrial, having decided that the court below could not stand. And so much of what my friend relies upon is just shooting at the wrong target in my submission. We also don't think there's anything between us on the effect that the appellate court can't make its assessment without necessary findings. It relies upon an authority on rather extreme facts where there have been no cross-examination, but we don't think there's anything between us on that. But we also don't think there's anything between us that it's a last resort when it's the only just resort. And our big picture point is that Lord Justice Burse, as we say in paragraph 159, took great care in identifying both the common ground and the judges of findings of fact which were needed. And we analysed that and explained what he was relying upon as we go through our paragraphs 90 to 103. There are 5 specific complaints that are advanced under ground 3. They're identified in my friend's paragraph 90, and we answer them in paragraph 160. Let me briefly deal with them one by one.
Sorry, which was the paragraph where you answered them?
160.
Thank you.
The first is a complaint as to a new approach as to which comparables were relevant, and we've answered that in subpara A on page 146. What Lord Justice Burse did was take the judge's decisions as to which were evidentially useful comparables. He also looked at the core of the judge's approach of putting them on a common scale, using inography. That was disputed at trial but accepted on appeal. He further used DPU, which was their preferred way of doing it as between DPU or AV. And he didn't actually have to pick between the experts because it made no significant difference. And he explained why the Apple licenses implied figures that were too low and the Google figure too high. And we've been through what he did, but the Apple licenses being too low is not a new approach or decision. It flows from the correction of the judge's error. So there's nothing in the first point in my submission. The second point is an allegation that the Court of Appeal considered a new case involving reliance on a single comparable. It was always a possibility that the court would select only one or a few of the licences, so it's not a new case in that it was always a possibility. And we were just merely accepting that the only licence that we'd put in that was left as available was the Google one. In any event, he didn't rely on just one licence, because that was what we were arguing. Doesn't mean that there should be a retrial. He didn't accept that submission. And a final point on this, perhaps conclusively, is that the substance of this point was rejected by Lord Justice Burse at paragraph 127, and that was a matter of evaluation, and there's no error in it. This point's already been argued and rejected. The third point is that the Court of Appeal created columns of data and comparisons for itself by way of original analysis. He didn't pursue this orally, and our answer is at paragraph 160 sub C. It was simple arithmetic, putting it on the basis of the new stack share, the 0.38%, and nobody suggests there's an error in this at all. The fourth point is to repeat the complaint about the prices separated by 5-cent increments, exactly the same as I've already addressed under ground one. And the final point is a criticism that the cross-check was cursory and flawed, and that's not fair characterisation in my submission. It's a conventional one. He used the 0.38% stack share determined by the judge. Before I leave that, can I just emphasise a point that we touched on in 161 of our printed case, and that's that we invite my lords and my lady to consider what a retrial would involve. It's actually quite a concern on this side of the court that we still don't know precisely what my friend's asking for, other than his...
Surely either the Court of Appeal determination, if we're looking at that, can be impugned, or it can't. If it can't, then it can't be a separate argument that they should have sent it back for a retrial, despite having made an evaluation which can't be criticised in principle.
I think you're right. The only point I was going to be making is that broadly it sounds like what he's arguing for is the kind of analysis that the Court of Appeal would be carried out anyway, because he's saying no more evidence. But I accept...
Obviously, if the Court of Appeal did, we think, make an error of principle, then we'd have to do something else.
I accept it. I accept the point.
Happily, no one's asking us to do the maths.
Are there any other questions that I can help you on before I let Mr Abrahams deal with ground four?
Well, suppose we were to decide that the Court of Appeal did make an error of principle, what should we do then? Send it back to a trial judge with as narrow a remit as possible, or what?
So an error of principle in its own approach, not in saying the judge...
Yes.
I mean, that might depend on what the error of principle was. Because it might be something which is actually capable of being dealt with without that. I mean, I just don't know.
Depends what the error. If no answer to that.
I think that's true.
Yeah.
I suppose if we issue a judgment dealing with the arguments in the case and expressing our views on them, you can then make submissions as to what the appropriate form of order.
I think we would have to, because we're shooting in the dark with not knowing.
Yeah. Even more than...
Is there anything else?
Thank you very much, Mr. Speck. Yes, Mr. Abrahams.
My lords, my lady. On ground four, our primary case is that under an EWCA FRAND licence, the licensee pays for all their licensed use. We say it would not be FRAND for a licensee to rely on a statutory limitation period, which applies to remedies for patent infringement, as a way of avoiding paying royalties for their use of the standard. A willing licensee would simply not do that or make that point. On that, I'm going to make 9 points. I'm then going to address our secondary case, which is that if it is FRAND for royalties to be limited by some sort of limitation period, that period should be calculated back from the date of first contact between the parties, not, as Apple contends, by reference to the date of the claim form. many or most or all of my 9 points will go to that, and I'll have a few additional comments to make on that point, on that secondary case. So on the primary case, we rely on the Court of Appeal's analysis by Lord Justice Arnold and some additional comments by Lord Justice Nugee in the Interdigital and Lenovo case, which, just for reference, you have in the bundle at starting at 2716. We've analysed that judgment in our written case, so I'm not going to repeat that analysis, but I'm going to focus on points arising out of Apple's submissions to this court. So my first comment, by way of preliminary comment, is that it's common ground that no limitation period is applicable to the proceedings before this court. The relevant question is, what are the terms of a FRAND licence, and to what extent the existence of national limitation periods for patent infringement remedies has a bearing on those terms. And to answer that question, one asks, what would a willing licensee and a willing licensor agree? Now, in that context, it is crucial to have in mind that the balance struck by the ETSI framework is very different from the standard statutory patent bargain. This court was very clear in Unwired Planet at 87 that the award of damages is not to be equated with the royalties that are paid under a contractual licence. And that's for lots of reasons, but in particular, the patentee working within the ETSI framework has to give up their exclusive rights, in particular their right to exclude others, as well as their claim to damages and their claim to an account of profits. That's why the FRAND licence just simply can't be compared to patent by patent damages for infringement or any other patent remedy. Second point, you need to consider the scope of the FRAND licence, because on Apple's case there is a serious disjoint between the Licence Act and the royalty payments. As you're aware, the vast majority of the terms of the court-determined licence have been settled and are not in dispute. It's just effectively just the value, the number that is in dispute. In particular, it's not in dispute that under the court-determined licence, Apple will get a complete release in respect of all products it has ever sold. Just for reference, that's clause 3.1, which you'll find at page 263. But Apple says that it should only have to pay in respect of devices which it sold after 25th of February 2013. It wants a release for devices sold before that date for free, and that's not FRAND. But it's worse than that. Apple needs a release for devices which it sold prior to 26th of February 2013, because even if its own infringing acts are outside the limitation period, it is concerned about the subsequent downstream infringements by its customers and end users, which are within the limitation period. Now, Mr. Speck showed you paragraph 15 of this court's judgment in Unwired Planet, making the point that an implementer needs to be able to bind the SEP owner to allow its customers to import, sell, and use its devices going forward throughout the world. So even if a particular act of sale by Apple is now time-barred, its subsequent the subsequent downstream infringements are not time-barred. And Apple is acutely conscious of this, and that is why the court-determined licence explicitly covers Apple's customers and all subsequent purchasers, sellers and users of the devices.
But the time bar applies to them just the same as it does to Apple, doesn't it?
No. No, with respect, no.
Okay.
Let me just give you the reference of the clause and then explain. So the reference is clause 1.4 of the court-determined licence, which defines Apple-covered parties. Apple-covered parties means anybody who gets their hands on an Apple iPhone. And those people will get a forward licence under clause 2.1 and a release under clause 3.1. That's page 263. And the answer, I'm now answering your question. Consider an Apple 4G device sold by Apple in January 2013. That device will have been used to infringe the patents within the limitation period. Those devices many of those devices would still have been in use when proceedings started in 2019, and their use by the businesswoman travelling around the world will infringe the patents in all those jurisdictions. And the sales after 26th of February 2013 by distributors, resales on the second-hand market, uses of those telephones will all have infringed. And as I say, those devices would still have been used in 2019. Some of them, some of those devices probably still in use today.
But does that make a difference if the original sale is now time barred? The fact customers may be still infringing the patent thereafter and within the time period that's just life. But it would be a pretty bold phone manufacturer to say, well, I know I can't chase the original manufacturer for these, but my goodness me, I'm going to chase their customers.
But the point, the answer to that is that would be an answer to a license which simply granted them a release in respect of sales back to some notional limitation period. Mm-hmm. But this license actually grants a license and a release to those people for no consideration. And this court, as I say, this court has explained why it's very important for SEP owners to get such a release and forward license for the benefit of their customers.
The implementer.
The implementer.
Yeah.
It's very important for the implementer wants that license and release. Under this court-determined license, it is going to get that license and release. So all of those uses all of those infringing acts within the limitation period in 2014, 2015, 19, 2026 is all licensed. And that's a huge benefit to Apple, as this court recognised, and made a particular point of making the point that that's a huge benefit to Apple. And for it to get that for free is just perverse, let alone non-FRAND, in my submission. My third point is that Apple's submissions do not reflect the FRAND framework. And one approach, I'm going to show you the documents in a moment, and if I may, I'm going to show you them as quoted by the Court of Appeal, because you then get their commentary on those documents. The starting point is that an implementer, of course, requires a license from day one, because they are otherwise infringing a patent from day one. And therefore, a willing licensee wouldn't just simply happily go on acting unlawfully, but would proactively contact SEP owners for a license. You saw the Court of Appeal saying that. The important point for present purposes is that is exactly how ETSI intended the system to work. And so the materials are helpfully set out in the bundle in the Interdigital and Lenovo judgment at starting at 2734. And if you've got 2734, you see the heading refers to ETSI materials. At paragraph 34, Lord Justice Arnold refers to the ETSI guide on IPR. And if you want to read the ETSI guide on IPR, it's at page 2359. But just could you quickly skim read that, which is set out at 35. And then just an additional reference to the same document but not quoted. Paragraph 3.1.2 of the guide, page 2371 of the bundle, states in terms that potential licensees should contact the patent holder. And at paragraph 36, Lord Justice Arnold endorses Mr. Justice Mellor's observation about the ETSI guide. If you could read that. And then at 37, he quotes from ETSI's IPR FAQs, a bundle reference for your note, 2355. And you've got that set out, and again, the judge's comment at 38. One more ETSI document, if I may, not quoted. It's in the bundle at page 2380. And what you've got at 2380 is the front page of the ETSI database of IPRs. So this is all the IPRs that you need or are said to need to implement the standards. And in capital letters in the third paragraph, it says, prior to making a patent licensing decision and implementing any basis patent and or member of a patent family contained in the present IPR online database, potential licensees shall always contact the declarant. All of these materials are still current on the ETSI website, apart from the FAQs. And they show what is expected of a willing licensee by the ETSI framework. And even more importantly than that, when an SEP owner gives an undertaking to ETSI, they're giving an irrevocable undertaking to give up aspects of their exclusive rights, instead grant FRAND licenses to all who ask for them. And they do so on the basis of the FRAND framework. They don't give an undertaking that an implementer may implement the standard, infringe their SEPs without seeking a license for such acts, sitting on their infringements, and instead waiting to see if they're approached and then taking a stand on a limitation period when they're approached. So that is one answer to my Lord Reed's question, which was, if the parties have not behaved in the way that an idealised licensor and licensee would have done, why do the FRAND conditions then have to reflect the idealised hypothesis? It's because the FRAND undertaking, which is right at the core of what we're all doing in this court, is predicated on this ETSI framework. A second answer to that question is, if not, you're rewarding and incentivising non-FRAND behaviour and penalising implementers who do act in accordance with the ETSI FRAND framework. And a third answer to my Lord's question is that this court in Unwired Planet said that the FRAND obligation extends to the fairness of the process. That's paragraph 64. And we know from these documents that a process in which the implementer infringes the SEPs without seeking a license for such acts, just waits to see if they're approached and then takes a stand on limitation when they are approached, is not compatible with the ETSI FRAND framework, and therefore just not the FRAND process. Fourth, I need to address Apple's submissions on industry practice. Now, in summary, I'm going to make 3 points under this heading. A, there is a finding that SEP owners often have to give some sort of discount on past sales. Some sort of discount. That is due to the difficulties of enforcing their rights. But B, there is no finding of an established practice of licenses being based on limitation periods, i.e. paying royalties backwards up to the limitation period and then nothing before then. And my learned friend's submissions muddle up points A and B. In any event, C, the discounting for past sales, even though it does happen in the industry, does not in this instance reflect FRAND, by which I mean the behaviour of a willing licensee. So in relation to points A and B, the actual industry practice, the findings of the judge are in two places. The first place is on page 608. Right at the bottom of the page, footnote 618. It's the last two lines of footnote 618. There was a great deal of evidence before me suggesting that past releases were valued differently from and lower than future licenses. So that's talking about discounts for the past. Nothing there about any practice in the industry of paying for the past properly but then cutting it off at a limitation period. And the point is a bit clearer in the consequentials judgment, which is on page 661. If you're on 661, paragraph 64, little Roman 2, says, the evidence before me was that lump sum licenses tended to be both forward and backward looking, i.e. they contained a license going forward and a release against past infringement, but that a discount was applied in relation to the past release. Again, no finding or even suggestion of a practice that you would have a limitation period, which would necessarily involve a full payment to the back to a limitation period and then a cut-off. So my learned friend's submissions yesterday assumed the existence of the finding that he wants, but none exists. Now, I should be clear about this. It is true that Apple's evidence was that they, being one company, considered that they should not have to pay beyond a limitation period. But the evidence did not come near to establishing that there was a settled practice accepted by both sides in the industry, which is important, of licenses providing for payment in full back to a limitation period but paying nothing before then. And the proof of the pudding is in this, that what my learned friend relied on to fill his gap in lack of findings, lack of evidence, was relying on self-serving statements by the interveners instead of evidence or findings in this case. Now, it's, I'm sure your lordships are aware of this, my lady, it's Practice Direction 4.54, which provides that interventions should not introduce new evidence. And that's obviously for very good reason. If I could cross-examine the interveners on their statements, I'd have a lot to say. But one thing in particular that I would expect to be able to establish is that they were muddling up the general idea of just paying less for the past with the specific point which we're talking about, which is the use of limitation periods, just as my learned friend made that muddle. Nor, obviously, can my learned friend fill that gap by relying on findings in another case. He took you to Samsung ZTE, which is obviously impermissible. That's a Hollington and Hewthorne point. Now, in relation to point C under this heading, Mr. Speck has explained why what happens in the real world does not necessarily reflect what is FRAND, i.e. the idealised standard. In this case, there are relevant findings of fact by Mr. Justice Mead in these proceedings in Trial F. Mr. Justice Mead made these findings having heard expert licensing witnesses and expert economic experts, witnesses, and cross-examination of those witnesses called by both sides. And the judgment is at 759 of the bundle. And the
759, did you say?
759.
We're jumping straight into the middle, but that's all right.
Yes, I hope that's okay. The issue in Trial F was whether Apple was entitled to rely on Optis' FRAND commitments to ETSI, given that they had not, at that stage, undertaken to take a licence on FRAND terms settled by the court. That was the issue being decided. And the parties adduced a great deal of evidence on industry practice for that purpose. And these two paragraphs which I'm showing you, 240 and 251, are part of that longer section analysing the evidence as to how the market worked and how that related to what was FRAND. So if you could read 240 and 241.
241?
240, 241.
Thank you.
Clear findings.
They are nice, clear findings. And I notice what clearly isn't there is a finding of the industry practice that my learned friend would like there to have been in this case. And the conclusion is on this, that's relevant to this, is in the final sentence of 245. So it's the very last word on page 760 and over the page. The effects of delay tend to be asymmetric and affect SEP owners significantly more badly than implementers. And he observes in the next paragraph that his assessment of the expert evidence is entirely consistent with the view expressed by the Supreme Court in paragraph 10 of UKSC, which was that implementers may unduly drag out the process of a licensing negotiation and thereby force the owners to accept a lower royalty rate than is fair, i.e., this asymmetric effect of delay results in sub-FRAND royalties. So there's consistent recognition of findings of fact in this case and in principle by this court in Unwired Planet, that to the extent that there is an industry practice of implementers getting away with paying less for the past, that is based on non-FRAND reasons and leads to non-FRAND results. The asymmetrical harm caused by delay is that the SEP owner is forced to accept sub-FRAND royalties. Now my fifth point, which is to address Apple's argument that the ETSI framework approach is not practical. And for that, Apple relies on paragraph 499 of the first instance judgment. One point to make about that judgment, that paragraph, is that it contains no actual analysis of the practicalities. An even more important point to make about that paragraph is that when writing his judgment, the judge had forgotten the ETSI materials that I've shown you, which he had been shown, which cast the burden onto implementers to contact the SEP owner to seek out licenses. How do I know he'd forgotten that? Because at the consequentials hearing, he observed that he had not been shown those materials when he was shown another judgment. If you want to go and see it, it's the transcript of the consequentials hearing is at page 1677. It's page 37 of the transcript, where he said he was intrigued to see these materials. And if you want to see me trying diplomatically to tell him actually he had seen them and forgotten them, that starts at page 44 of the transcript, me trying to do the best I can to be delicate. So there is no basis for the judge's finding in 499. There's certainly no basis for suggesting that there's any difficulty in identifying who owns portfolios of SEPs. And furthermore, Mr. Justice Mead explained in Trial F that it is practical for implementers to make financial contingency for licence fees, as envisaged by the ETSI framework. You have seen that paragraph. Just for reference, it's paragraph 227, page 758 of the bundle, and it is a finding of fact in these proceedings. My learned friend says that a contingency fund cannot be retained forever. But the ETSI framework does not say that you just put money aside and sit on it forever. It says you approach the SEP owner for a licence for your ongoing unlawful acts, and in the meantime you put aside money until you've reached agreement, and then you pay it over and maybe even recover some if you've managed to do a good, fair deal. My sixth point addresses the policy aspects of statutory limitations periods. Statutory limitation periods are predicated on the claimant being able to bring proceedings at any time during that period. So, for example, they don't run when the claimant is under a disability. But in the ETSI FRAND context, SEP owners are expected to negotiate first and not enforce their patents during those negotiations, which can last years. The importance of negotiation before enforcing patents being emphasised by the CJEU in Huawei and ZTE and by this court in Unwired Planet at paragraph 10. Indeed, in these very proceedings, Apple's pleaded case was that Optis had brought litigation precipitously and thereby illegally under competition law. You then add to that the inevitable fact, as this court recorded in Unwired Planet, that it is particularly difficult for SEP owners to enforce their patents, given everything that involves, amongst other references, Unwired Planet 10, paragraph 10 and 166. Therefore, when you consider the whole universe of implementers that the SEP owner has to worry about, the years that negotiations may take, the restraint that the SEP owner is supposed to show before suing, the costs of negotiations and the costs of legal proceedings around the world against big beasts such as Apple and others who are not so big but still very big, It's just unreal to expect a SEP owner to initiate proceedings against all implementers within 6 years of a standard being implemented, as well as actually being quite undesirable and totally contrary to the ETSI framework, how the whole system is supposed to work. And that's a complete answer to Apple's reliance on the policy aspects of limitation periods. Seventh, I need to deal with Apple's points on incentives. Now, Lord Justice Arnold addressed this in Interdigital and Novo at 192 to 193, and I'm incorporating all his submission, all his part of his judgments into my submission, so I won't go to that now. The key point that he explained there is that there is no incentive for the SEP owner to delay or sleep on their rights, as opposed to a big incentive on implementers. And because the SEP owner is given an irrevocable undertaking, he can't get an injunction if the implementer doesn't seek a license or refuses to take a license when approached or drags out negotiations, because he's given that undertaking, and if he gets a finding of infringement and validity, the implementer will simply say, well, I'll take a license then, and I'm entitled to a license to that one patent in this one country. My learned friend's concerns about this are therefore unreal. There is absolutely no benefit to an SEP owner sitting on their rights. On the contrary, delay asymmetrically harms the SEP owner. Eighth, this court should not give too much credence to unlikely or exceptional theoretical possibilities. In particular, it's common ground that there may be case-specific factors that could point to a shorter period of payment for the past. We completely agree with what my learned friend said about the possibility of such case-specific factors, and that would obviously cater for the sort of wild, unlikely examples. Obviously, it's also common ground now that this is not such a case. Finally, I should just mention, ninth, Apple's written case tried to link this question to the interest rate determined by the judge. But that was, on analysis, that's a complaint about the interest rate. The interest rate awarded by the judge can't help your lordships to answer the question raised by ground 4. So I turn to Optis' secondary case. If willing parties would, in their hypothetical negotiation, factor in a limitation period, then any such limitation period would be reckoned by reference to the date of first contact. That's the only option consistent with the concept of the willing licensor and the willing licensee, and the only option compatible with the expectation that SEP owners will negotiate, rather than doing what my learned friend proposed, which was immediately initiate multiple suits in multiple jurisdictions. I've already made my submissions about how that is both undesirable, unreal, and contrary to all the authorities in this case, such as Huawei and ZTE and Unwired Planet, which emphasise the importance of negotiation and not suing. Apple's position would obviously reward implementers who drag out negotiations and incentivise SEP owners to rush to court. Now, my learned friend, Mr. Speck, showed you paragraph 187 of Lord Justice Arnold's judgment in Interdigital and Lenovo, which made the point that a willing licensor and a willing licensee would begin by negotiating a standstill agreement in order to ensure that the passage of time during the course of negotiations did not affect the substantive terms ultimately agreed. End quote. And that's obviously what a willing licensee and willing licensor would do. What they wouldn't do is say, okay, well, you, SEP owner, you start proceedings everywhere in the world on every patent in your portfolio, and we'll agree a stay to all those proceedings, and then we'll go and negotiate. That's obviously not what would happen. They would agree a standstill agreement, as the Lord Justice Arnold said. And he went on to observe that on that, considering the very point that I'm now addressing, on that basis, the relevant date for the purpose of determining what terms were FRAND would at the latest be the date of first contact between the parties. As I say, that's paragraph 187 of his judgment. And of course it chimes with the point made by this court in Unwired Planet at paragraph 10, which is that there's an expectation that negotiation will take some time during which the SEP will not enforce its SEPs. It would just not be FRAND if time was running against the SEP owner during those negotiations. Now, even Apple, who you've seen took every point that they could in negotiations, accepted the point that I've just suggested. Can I ask you quickly to look at page 1610 of the bundle. So 1610 is the cross-examination of Heather Muse, who was Apple's chief licensing person. That's my summary, not her job title. And if you want to read the full passage, it starts on page 634 of the manuscript at line 8. But I'll just draw attention to the key parts. At 636, Mr. Speck, the cross-examiner, put to the witness, so the willing licensor and licensee would not proceed on the basis that for every week that it took to negotiate a deal, the licensor was disadvantaged financially, potentially by several $1 million. Agreed? Yes, I agree that in general that is fair. As I said, there could be particular circumstances where they may not be fair. But that would give the implementer a perverse incentive to take longer, wouldn't it? But, for example, the licensor could take longer. And then the question at 18 is asked, but then there's then a problem with the sound. So it picks up again at page 637, line 10. My learned friend, Mr. Speck, says, Ms. Muse, what I'm suggesting to you is that at the get-go, the reasonable willing licensor and licensee would agree that the license that they are negotiating would cover all sales that were actionable at the time of the initial approach. I think in general, yes. There's one more answer, but just to explain the next answer, Apple's position was that sales for the past were treated differently from sales for the future. And so, for that reason, Mr. Speck asked, similarly, they would agree that the level of payments would not change by some sales being made in the interim and going into the past, i.e., when you start negotiation, the sales for that year will all be in the future, but by the end of negotiations, they might be in the past. On Apple's view, that meant a different payment number. And she agreed at line 19 that wouldn't change the amount of the level of payment. It wouldn't reduce it, even though she was saying that in general sales for the past go into the past. So she absolutely agreed with the concept that the parties would agree that time should stop running once they start negotiations. Now, as my Lord Briggs explained, this wouldn't be an irrevocable standstill. It would just stop time running so long as both parties were negotiating and consider that they could reach agreement without litigation. And as I think I've already made this point, that's a much better way of dealing with the point than issuing proceedings all around the world and then trying to negotiate and agree stays, which might not even be possible in some jurisdictions.
It's been put to her, and she agrees that you would take into account those sales that are actionable at the date the first contact is made.
Yes, well, I'm addressing the second. That's why I'm addressing this.
No, I understand, but the quote, it's put to her that would be the position of reasonable licensors and licensees, and she agrees.
So she has made it quite clear that, in her view, she wouldn't contemplate paying for sales before that were not actionable in that sense. So it's put on the assumption. It's put on that assumption. So I obviously do not and cannot rely on that answer in relation to my primary case. But that answer doesn't damage my primary case because she's made it clear that she doesn't agree with my primary case, and the question is just put on that basis.
Thank you.
Finally, the claim form can't be used as the relevant date for a FRAND licence because willing parties would agree a payment for the past without litigation. And likewise, real parties who wish to agree FRAND without litigation, including parties who look to this court's judgment to see what is the right answer to the FRAND question, they cannot reckon from the date of the claim form because there won't be one. So it's a wholly impractical and unhelpful answer to the industry, as well as being non-FRAND for time to be running during the negotiation period, and clearly not what willing parties would agree. My lords, those and my lady, those are our submissions on ground 4, unless there are any questions that I can help you with.
Thank you very much, Mr. Abrahams. Yes, Mr. Turner.
May it please the Court. I'll deal first with Mr. Speck's submissions. in the response in the course of today on our valuation grounds, with his major focus being on ground 1B, the challenge to the Court of Appeal's decision that all Apple's licenses are depressed because of holdout, trial judge's decision, and their decision to reverse that finding on the evidence and then to use it in their methodology. Second, I'll deal with Mr. Abrams' response just now on limitation period issues. And third, and I shall need a little bit of time for this if I can get through, I would like to deal with the submissions on the first instance judgment, which Mr. Speck addressed yesterday and which occupied the entirety of the afternoon. So if I may begin with ground 1B, the holdout ground. First point is just to recall the first key point in our appeal case on this, which is that the Court of Appeal was wrong in principle. This is before you get to paragraph 122, but it feeds into the reasoning. They were wrong in principle to consider that a departure from the idealized standard of hypothetical parties entails that there's a degree of holdout or hold up, and therefore the outcome cannot be taken as FRAND. Our case is that, drawing on paragraph 62 of this court's ruling in Unwired Planet, the proper yardstick is the real world where parties bargain as hard as they can, and unless there's specific reason to conclude that one or other counterparty has exerted economic pressure or in some other way achieved a rate that's artificially elevated or artificially depressed, then it is a reliable guide. And we say that this is how, ultimately, and I'll make the points good on this to the extent I need to again, the trial judge in this case approached the matter. I should say that we do not say, as said at one point, that Apple's position is that the fact of licenses existing in the real world, ipso facto, entails that they are FRAND. I've said that in my opening. If one takes this very case, the court is aware that Apple does not say that the anomalous Qualcomm license is FRAND. That was never part of its case. Now, the crux of the Court of Appeal's reasoning is paragraph 122 of the judgment. And there, the Court of Appeal overturns the judge's conclusions that there's been no artificial depression of rates, based on its assessment that he applied a test first that all lawful or legitimate behaviour comes on the FRAND side of the line. Says that was wrong, but then the Court of Appeal, I should say, reaches its own conclusion on the substance based on two combined factors: patent-by-patent licensing as a practice and the spread of rates. Now, today, Mr. Speck started by seeking to support the first of these factors, the patent-by-patent licensing, and he began by showing you a partial selection of underlying evidence. Only after that did he turn to the judge's reasoning and findings in the judgment. I'll be very brief, therefore, in relation to the underlying evidence. That is to effectively treat this court as a further court of first instance and advance additional submissions to you. He began by taking you through a slide deck, which is at page 1923 of the bundle. I should say for the court that there was extensive cross-examination at the trial, both about this and about Apple's statement on the website, which he took you to. The witness, in certain material respects, contradicted the account that was given of the interpretation of, in particular, that slide deck. We have filed with the court, and I hope that the court has it, pursuant to your request, a note on what the Court of Appeal had and what it didn't have. That should have come through to you, but at any rate, we'll ensure that it does if it hasn't found its way. And at the foot of page 2 of that note, we refer to the disparity in relation to this particular issue between what was available to the judge at the trial. There were 40 manuscript pages of cross-examination of the witness on this, and what was available to the Court of Appeal. On this issue, 4 pages. There were no findings by the judge, as the court correctly apprehended, on this issue either, relating to this slide deck or this statement, nor even were there findings by the Court of Appeal. You do have the wider findings of the judge, which contextualise this, ones that refer to the fact of big beasts on the other side of the negotiating table, those being entities that can threaten, credibly, to shut down Apple's sales operations in major territories, whether Germany or Colombia or Brazil. Now, this was said, again, to be somewhat fanciful. I'll give you simply the following references. The witness referred to the reality of the injunctions. I'll give you one place, page 1614 of the bundle, and won't ask you to turn it up. What was said was that this was a practice which was not temporally live at the relevant time. In relation to that, may I recall that in the Court of Appeal's judgment in Unwired Planet 2018, at paragraph 4, where I began my address, I referred to the Court of Appeal's point that the injunction threat remains live after the introduction and acceptance of the ETSI framework, and that in our written case, lest it be forgotten, at paragraph 49, which I believe is page 70, you can pull that up, page 70, there were references given to the evidence before the judge of negotiations of the licenses in this case, not subsequent, where large-scale litigation was brought. Now you have also, to the extent that you admit it, as we say you should, Mr. Justice Mead's judgment very recently, at paragraph 28 in particular, page 2943, on the reality of this, and drawing back the threat of injunctions and their reality as a stick with which to beat implementers, even Samsung and even Apple, was live both before the Unwired Planet decision as well as after. Now, my friend referred to the negotiations and took you to certain negotiation documents. He gave you, may I say, an incomplete picture of the negotiations, both in the items of correspondence that he showed you and outside their framework. If I may give you just a couple of counterbalancing references and move swiftly on, you see the general flavour of the negotiations that the judge saw. You turn in the bundle to page 1770, where you'll see on the same page there are essentially 2 emails, the first in time at the bottom, the response at the top, with the parties essentially accusing each other of this, that and the other. This is the sort of behaviour that the judge saw much of, which led to the statement in his judgment to which I referred in my opening. The other reference I'll show you quickly is on page 1800. Yes, and if you, I'm not sure, is this confidential? Okay, so Apple and the past negotiations with that party.
I'm sorry, which page?
I'm sorry, this is page 1800.
Thank you.
And you'll see that there's a heading, Apple's and a certain other party's past negotiations. And you will see in the second paragraph of that, Apple pushing back and saying, you're portraying us in a particular way. This is not accurate. This is a self-serving characterization. All of this goes to show that in these negotiations, the FRAND regime itself, ironically, becomes a tool of negotiation, with each party saying to the other that you are behaving badly and in breach of this system, with the consequences that may follow. Now, I leave aside, therefore, the correspondence. My friend said that I referred to Ericsson's action in the year 2022, which post-dated these licences and occurred during the currency of the first instance proceedings. I did do that. I did it first to show the reality of the injunction threat. It was one example. And secondly, to show, contrary to the suggestion you hear from the other side, Apple's posture in that case, which was to say, we are prepared for a single global license determination, in that case by the US court. The idea that Apple is bent on the contrary.
But that was after Unwired Planet. And one of his main points was that the landscape changed then. And up to that time, that wasn't recognised as a possibility or not a clear possibility. And therefore Apple was able, with impunity, to threaten to contest every patent one by one.
My Lord, that is a fair point. Unwired Planet and the global determinations followed that. However, the practice of negotiations and the practice of arbitrations took place throughout this period. In relation to arbitrations in particular, there was cross-examination of our witnesses, and they made very clear that the practice, in the period with which the judge was concerned, was one of a form of testing by proxies and what was described by one witness as a hybrid collaborative and adversarial process, which well describes it. May I give you that reference and ask you to look at that briefly, because you have not seen it. In the judgment, the judge sets this out. I believe it's page 496. Right?
Yeah.
So page 496, and as it's coming up, my recollection is at the bottom of the page. This is cross-examination of another Apple licensing witness, a gentleman called Mr. Ankenbrandt, and he is the target for the same set of allegations. And he says at the bottom of that page, and you can read for yourself, how most people we negotiate with behave. They understand a negotiation is about hybrid adversarial and collaborative process. Sorry. And so forth. So I draw that to your attention because it's a good crystallization of the point that the judge saw about the way things actually work. And now, if I may, I turn to his findings. I leave all that underlying evidential material to one side.
I mean, a curious aspect of this is that, for example, the conversant one that he was talking about is one that postdates our judgment in Unwired Planet. There are several of them which do postdate it.
Yes.
And so by that stage, people, at any rate, know that courts will grant, will fix global FRAND licenses. And yet all the Apple licenses that were relied on as comparables that post-date our judgment were disregarded by the Court of Appeal because they weren't amongst the highest figures.
My Lord, yes.
They only looked at the top four.
Yes. My Lord, yes. In relation to this, I would say, the point is well taken. I would say only that this description of the negotiating process generally was a matter that the judge referred to as affecting all of the relevant licenses that he included in his group, without him drawing the distinction that your lordship has made.
No.
He saw this as the general position. And with that, if I may, I'll go to my friend's next topic, which is to put aside the underlying evidence and look at the findings that were made by the judge. My friend took you to these again. I shall be brief because I went through them carefully in my opening. But he began on page, I think, 459 with paragraph 206. And he made certain comments about that. He recognised, and it was put to him by Lady Simler, following paragraph 207 contextualises what was said in 206. Then you get the high point, as I put it in the opening of their case, which is 211C, in relation to which, in the exchange that the court had with Mr. Speck, I say only this. Contrary to his submission, There is not a finding of effects. There is a finding of a negotiating ploy, but it is not a sensible construction of what the judge says, that he finds an effect of artificially depressing rates. It is inconsistent with the wider findings he then goes on to make, as well as not saying it explicitly. For those wider findings, there are two key paragraphs. The first is the one relied on by, by Lord Justice Burse at paragraph 417.3, referred to specifically in the Court of Appeal judgment at page 567. 417.3. Sorry. Yes, that's it. And in particular there, as the court picked up in relation to A, the gist of the judge's concern is with negotiating strength. And whichever levers they have used, whatever lawful strategies they have applied, has one party overborne the other in the negotiations so as to achieve either an artificially high or low rate. Then in 481, and particularly at Roman 4 on page 596, again, and my Lord Leggett picked this up as well, essentially the concern of the judge is of the application of economic force by one side or the other. Here, standing back, the sensible construction of what the judge did and the natural construction is that he saw the issue being that where one has big beasts on both sides of the table, one can and should treat the outcome itself as a FRAND yardstick. So I say no more about that.
Well, isn't a crucial question whether that was a legitimate approach or not?
It is.
What's argued against you is that the judge was mistaken to take that view, and that although economic power was one relevant factor, another was whether the approach that was used to achieve the result was one that a willing buyer would have used, or whether it was in fact an exercise of the sort of behaviour that is described generically as holdout.
My Lord, you're right. First point is, as I said at the outset, that the Court of Appeal's appreciation that one takes the idealised standard, and that if either party departs from it by using strategies that it regards as not cricket, that means that the outcome cannot be FRAND, and I passed over that. Here...
That's slightly different point. Yeah.
Yes. Here, the question is whether one is only concerned with strategies that are not cricket, that are themselves, let us say, a form of holdout behaviour which is obstructive or to be frowned on in its own right, or whether one goes wider. In my submission from these paragraphs, what one sees is the judge says, if I'm looking at behaviour in negotiations as an issue, then one has to be careful to look at behaviour which is obstructive and problematic. However, if I am undertaking the task of a FRAND determination, I go further, and I do say that the more general, the most important consideration, as he puts it in 481 Roman 4, is the wider issue of economic pressure. Economic pressure may be applied using such behaviour. It may be applied otherwise because you have a mismatch in size and resources. We say that there is nothing objectionable about that when one comes back to ask oneself, what is the ultimate purpose of this exercise? It is to find rates which are reliable guides, the outcomes, to setting a fair rate for the market, as this court said in Unwired Planet. You achieve that result if, as the judge says, one is looking to competitive negotiations between hard fought between individual companies, which are the stuff of a market economy, and that gives one the guide to be able to assess FRAND reliably. And indeed, I come back to the starting point, this court's judgment that EWCA intends that one looks to commercial practice.
Yes, just on that point, we haven't been taken to these materials, but I've noticed that the EWCA guide, all it says about negotiations is that they should be honest and impartial. I think that's paragraph 4.4 of the EWCA guide. And the CJEU has said something about this in a case which we've got in the bundle, called Huawei, where they spoke about negotiations being in good faith, conducted in good faith, and in accordance, I think, with ordinary commercial practice, is the way they put it.
Yes.
So in other words, you don't behave dishonestly, and you comply with the ordinary practice of your branch of commerce.
Yes, exactly. I believe your lordship may be referring to Huawei and ZTE.
See, it's the one we've got.
Yes.
That starts at page 3485.
Yes.
Yes, ZTE, you're quite right.
Yes, absolutely. And as this court found in, I can't remember which it was, paragraph 82, but I'll be given the reference.
I mean, it's rather, both the EWCA guide and the CJEU judgment are rather more precise than just talking about FRAND negotiations as if it were a game of cricket.
Yes. They talk about good faith, and they are more prescriptive as to how one ought to do it. Yes. My lord, that's a point worth taking. That is a point well taken. However, the ultimate question for present purposes is not merely whether the behaviour that one brings to the negotiating table is relevant to the question of FRAND, but when you are determining a rate for a particular licence, what outcomes can you have regard to?
Yes, exactly. That must be the whole point of it.
Yes. So
But the whole point of identifying holdout and hold up is a recognition that practice that may be perfectly legitimate, hard-fighting market negotiation, is not all practice that should be ignored for the purpose of whether you give weight to a valuation that was agreed or not. You have to kind of extract, don't you, hold out and hold up, and what influence that had.
My lord, yes. And we say that that is in line with the approach of the trial judge in the relevant paragraphs, 417 and 481, essentially, where what he says is, if it's competitively argued negotiation between big beasts, one can generally assume that the outcome will be a reliable guide to a court undertaking this exercise, but he qualifies that by saying that if there is evidence, specific evidence, of overweening pressure on either side, then that must be taken into account. We say that that approach, rather than the Court of Appeals analysis, is correct. There is one additional point in relation to ground 1B. I'm not sure I need to cover this in any great detail. It was that the Court of Appeal was wrong, we say, to find in paragraph 121 that the judge's averaging necessarily assumes that all the Apple licenses are, similar to Optis, licenses only for cellular SEPs, stripped down. I've taken you to the point that the judge found that there were what he described as opacities and ambiguities affecting all the Apple licenses before him. That's page 484, paragraph 2452. And that the objective information he had did not enable him to treat any of them in its own right, by itself, as a close parallel to the situation before him, the Optis Apple license, for the purpose of determining a rate. And what he recognises in that footnote 300 that we looked at only a little while ago in different context is that the lump sum rates, I'm using the judge's expression, the lump sums in the Apple licenses were negotiated deals based not only on volumes sold and selling prices, but on, as he says, other factors. Once one appreciates that the judge saw this, the notion of Lord Justice Burse that he was assuming something else, something different, cannot be accepted. And so we say, for those reasons, on ground 1B, we should succeed. Turn to ground 1A, and this I can take much more swiftly. This is the cimetidine point. Before this court, yesterday, I understood that Mr. Speck was no longer saying that the right approach to a FRAND determination is to search for one or more best comparables in every case, that it was a matter of common sense or pragmatism. The Court of Appeal's finding on that matter, which is in paragraph 115 of its judgment, appears therefore to be unsupported by the respondent as a legal point. To the extent that the Court of Appeal is articulating a legal approach, which is the right approach, we say that that is wrong, and I shan't repeat my opening on that. In short, the question of a multifactorial evaluation is a fact-dependent matter. The Court of Appeal in this case, to come on to what my friend said about this ground a little while ago, was not applying cimetidine in any conventional sense. They were not using best comparables. It is true that Lord Justice Burse refers to, I think, the Google license and the Apple licenses at two ends of this range as the best comparables. But what is meant by that is simply these are my only data points that I have before me. It doesn't mean the best comparables in the sense that Lord Justice Lloyd and Lord Justice Nichols were referring to in that case. And whether it was appropriate for the Court of Appeal here to proceed in the manner it did is a separate matter, but it is not justified by the approach that Lord Justice Burse says that he is pursuing.
Well, I'm not sure that the distinction that the Court of Appeal discovered between comparability and reliability is quite as clear as they thought it was.
No, it is not. The two mix into each other. If I may then turn to grounds 1C and 1D, I now move from their criticisms of the judge, essentially, and their findings in relation to that, to the application of their own methodology directly. Ground 1C, if you recall, was our complaint about their choice to use the Optis Google license generally as a yardstick for their assessment, because they themselves found, in the clearest possible terms, that it was far too high and problematic. Yet, it was used as an integral part of their methodology. It was used in the first place not only as the top of a range, it was used also to find that all of the Apple licenses, and not merely some of the Apple licenses, were too low. And if I may return to that part of the argument with my friend a little bit earlier, we understand that at the earlier part of the judgment, paragraph 122, the findings my Lord Reid says is that the conclusion of the Court of Appeal is that some of the licenses of Apple must be affected by holdout, because where it can, it uses its negotiating power.
Well, if I said that, I misspoke.
I'm sorry.
I think it's pretty clear they think they're all affected, they're all too low, and that's why they only look at the highest ones, and they assume that, or they posit that the correct figure must be above any of them.
My Lord, I'm sorry. In that case, it's my fault. We agree with the conclusion that that is their proposition. But we understand, having read this judgment a few times, it may still be wrong, that that conclusion comes from paragraph 138 of the judgment, where, if you read it, Lord Justice Burse says, the second conclusion I draw involves taking the Google license into account. So he's now using this
I think it comes from two bases. Yes. One is the Google license. The other is the discussion you've been having earlier about whether you can infer that Apple's used holdout to depress all the licences, or whether it didn't. Were they entitled to interfere with the judge on that point? Because they thought, I think, before they embarked on this, that they, in paragraph you cited before, 119 and so on, that they could infer that there was some effect of holdout on all the licences.
Well, he says there that there's a tainting, I agree, of all the licences.
And what part of your complaint is that he
it
shouldn't have inferred that it did have an effect, but he says it must do. The only question is how much.
Yes, I'm sorry, I'm corrected by Mrs. Sepsiu, so I will adopt what she says. She's right. He finds in 119 that a finding of a degree of holdup, that a degree of holdup or holdout was involved, leads to the taint. But then when he applies it in paragraph 122, a little way down, he looks at the spread of rates. And if you read from 5 lines or 6 lines down, the sentence begins, when it can do so, Apple's significant negotiating strength leads some parties to agree lower rates than would be agreed between a willing licensee and willing licensor. So he is himself saying there, at that point in the narrative, that it's some, as we understand it. Then if you go to 137 and 138 on page 310, you need to read the conclusions in turn. The first at 137...
Oh, he undoubtedly does bring the Google licence to bear, but I'm just questioning whether it's the only reasoning we have to be concerned with, because he's made a more general point.
My Lord, I shan't spend more time. I've made my point. But certainly at 138, he does use the Google licence essentially to show that all the Apple licences are too low, and therefore there needs to be an elevation.
And he keeps using it throughout the process.
Yes. And so our complaint about that I shan't develop, because the application of the methodology in greater detail is the next ground, 1D. But the starting point, we say, which is to use a non-FRAND licence to achieve this result, is the wrong starting point. Turning to the methodology itself in ground 1D, it is, as a threshold point, we say wrong to say that the Court of Appeal should decide, is best placed to decide, if it is in a position to carry out the evaluation itself, and that this court should respect the Court of Appeal's decision to do that, unless what it decided was wholly unreasonable. I believe that was the submission. If that was advanced, we say that is wrong as a proposition of principle. The point is that the Court of Appeal should not be proceeding in that manner in relation to a multifactorial assessment conducted by the trial court, save in the rarest circumstances.
But doesn't that depend on whether we can see that what they were able to do was adequate or not? And if it was adequate, are we then going to say that, oh, well, they shouldn't have they were wrong to take the view they should embark on that process at all, and that even though there's nothing wrong with their methodology, we should still upset what they did?
No,
it seems a bit.
Yes, no, my Lord, you're absolutely right about that, and you said that before. We agree. I'm dealing here first with essentially a matter of principle, which is the proposition that in such a case, the Court of Appeal may decide for itself whether it will undertake its own multifactorial assessment.
Oh, I see.
And it can only be criticised on the basis that the decision to do so was wholly unreasonable. We say that the lights by which it should steer itself were fairly clearly set out, most recently in Iconics last year, and I referred also to Chin and Chin, and your lordships are familiar with that range of authorities. So that was really just a point of approach. If I then look at the methodology...
Is that just shorthand for saying they just don't have enough of the material to do a reliable job, and they're island hopping?
Yes. My submission in this case, in agreement with my Lord Legate, is that in this case, and for the reasons I developed in opening, they did not have the tools to do the job, and where this court can feel that it was a safe exercise. Now, a couple of points only in relation to this. At paragraph 137, you'll see the conclusion that putting these 4 Apple licenses, top of the range, together shows that a DPU rate for Optis lower than those rates would be too low. May I pause there and draw an implication from the rest of my argument, which is that even if, let us say, the top of those, including those 4, take as an example Ericsson, is at a depressed rate compared to what it should be, why does the conclusion follow that Optis, with its different portfolio, SEP only, average quality, no business relationship, etc., why should it be above that? You can draw the conclusion that that one may be depressed, but to draw the further conclusion that the one you're seeking to determine should sit above that is a non sequitur. And it comes back to the point that the Court of Appeal had made in paragraph 121, that Lord Justice Burse was abstracting from the reality of what these Apple licenses were, and he was treating them all homogeneously as if they are simple, pure, cellular set only licenses. He then goes on in paragraph 138 to use the Google case as the yardstick for saying all the Apple licenses are too low, and I shan't say more about that. I would comment, I may have missed this, but I don't believe that my friend did deal in his address with the issue of the new upper threshold of the 27 cents, which is used by the court in paragraph 143, and the submissions that I made about that. I shan't repeat those now, but note that it was not covered, at least as I heard it. In paragraph 143, there are, I think, only 2 more points to make in relation to this. Paragraph 143, which is an important part of the methodology, the key point not addressed by my friend is that although he refers to the Court of Appeal assessing that something is either too far from this or too close to the other, he did not address the point made in my opening that there is no basis for gauging what is too far or too close. How do they know? Is it gut instinct? There's certainly no reasoning that would tell you the answer. And the final point is the top of the range point. I deal with that again smartly. If there are 2 FRAND points that a court has determined each to be in their own right at FRAND levels, it has been said that the offeror can choose the one it wants, the one it prefers. That was the dictum, paragraph 125 of the Court of Appeal in Unwired Planet. Here, there is a category difference because the Court of Appeal is seeking to determine a single point, one figure, and the maxim or dictum has no application to this situation. Here there is a balance to be struck between factors in choosing the single figure. And among those factors, and importantly, is the EWCA objective of low prices for consumers, affordability, and flourishing downstream markets. In this context, a consideration or principle that the patentee is entitled to the top of the range has no application. So I turn to ground 2. Those are the main valuation grounds. Ground 2 is the cross-check ground. My friend's right, it has 2 limbs. The first limb concerns the need to cross-check the overall affordability of licensing to the stack, the whole stack, for implementers, for product manufacturers, based on the decision of the court in relation to the licensing question. Now, I made my points in opening that the $40 is problematic as a cash sum. The answer on the other side is that effectively one can or perhaps ought to assume that there's a sliding scale, an ad valorem approach that would be adopted, so that the figure in relation to Apple would not apply to people who have cheaper devices. In relation to that, the points that I made in opening remain good. First, that in relation to Apple itself, the situation is that the court is consciously setting a rate higher than the highest rates paid to international licensors, consciously doing so for an average quality portfolio. In such a situation, it is to be expected to be necessary for a FRAND court to consider whether the implications for even that specific licensee are commercially acceptable. What the Court of Appeal does is to say, we see $40, we say that this is X percent of one Apple iPhone, Y percent of another, but there is no comment. There's nothing beyond the observation of the percentage levels. And if one is concerned with the commercial question and the workability of markets for consumers, one would need to know more than that. The Court of Appeal does not do that. Then one moves to the wider business community. My friend's point comes in, which is whether one assumes a sliding scale or not. Now, the judge did work in cash sums. The judge did refer to cash sums being the preferred method of approach for FRAND cases. He did note that in negotiations, selling price was also a factor. But in relation to FRAND valuations, he himself said that it's cash that counts. And so far as the Court of Appeal is concerned, more particularly, the $40 is a figure that's referred to both for two Apple iPhones at different price points, then the lower priced Google handset. And the suggestion that I make is that it should also, in principle, be applicable to a lower priced phone, for there's no reason why that is not shown to be the case. What was said was, in relation to our argument about that, where I had said that their expert had referred to phones being capped at a level of $250 by way of industry practice, was wrong, and that the expert was only referring to the situation in relation to Apple in a different context. If I may give you the reference to that, that was an incorrect submission. It's page 1584 of the bundle, paragraphs 414 to 415, which are in blue, so I will not read these out. But one sees from the heading of the table and the content of those paragraphs that the expert was referring to industry-wide practices, that after a price level of that amount was reached, in his estimation for that report, one does not further consider that any further money is due to the licensors. Let's say no more about limb 1. The second limb of ground 2 is the usability of earlier decisions of the courts, domestically as well as foreign, in FRAND determinations. The issue is a conceptual one, a matter of principle that we raise with a particular application. We say that it is appropriate for courts undertaking these exercises to be able to have regard both to the decisions and the findings of other courts, because it is an iterative conversation. It involves business people taking those findings and decisions into their own negotiations, and it is sensible in this context for the courts to do the same. We contrast that with the way that the Court of Appeal approaches it in paragraphs 44 and 45 of its judgment, where it seems to say that one looks to other decisions where they are decisions of foreign courts for reasons of comity, and does not mention the domestic court. So we say as a matter of principle first If that is what is meant, and I accept it is not entirely clear, then that is wrong. The specific application of that principle here is the fact that the court did not refer to its earlier decision in the interdigital case.
Well, it wasn't asked to, was it?
It was exactly. So the point was, we never asked them to do that. To which I respond, when would I have asked them to do that? We only, there's a certain irony in treating the judge's methodology as being unheralded and procedurally unfair. May I say that that is actually an incorrect submission? If I have time, I'll show you why. But what is certainly the case is that we never saw this methodology or outcome with the 9-fold increase until the handing down of the judgment. There was no opportunity for us to make this point in relation to that because we did not know what the Court of Appeal would do. Rather, and I'm not sure if I have the reference, I think in our skeleton for the Court of Appeal, which you will...
Is the Court of Appeal meant to be introducing new material into its valuation, which wasn't before the judge?
If the Court of Appeal is itself going to undertake, that's a point that opens a pertinent observation. If the Court of Appeal is going to undertake a multifactorial assessment in substitution for the trial judge, if it decides to take on that burden, it will need to have all the tools necessary to do the job properly.
Not beyond the evidence that was at the trial?
Not beyond the evidence that was at the trial, and if it decides that the evidence that it has is insufficient given what it proposes to do, that should give it pause. Here, you've seen that consciously it has decided we will set a new rate higher than all these other Apple rates. At that point, and this is the gist of our ground two, a responsible FRAND rate-setting court should attend to the consequences of essentially breaking out in a new direction. If it does not do so, then it has failed to take into account an important consideration that the ETSI policy requires a court to attend to, which is the affordability of its decision.
You're not saying it wasn't on the cards that the Court of Appeal might want to do it itself, as I understand it. I mean,
Well,
you're not suggesting that it was sort of common ground between the parties before the Court of Appeal. It was either a question of upholding the judge or sending it back, was it?
so two answers to that, my lord. The first is, I think it was paragraph 18D of our Court of Appeal skeleton. Friend will get the reference. We made the point to the Court of Appeal that they are a review court. They shouldn't be undertaking.
Well, that's you saying they shouldn't do it. My question is it simply not even on the cards that they might?
No, it was on the cards because then, just to complete this, at the hearing, it was put to me, and I think it's partly reflected in one of the paragraphs of the Court of Appeal judgment, can we do this ourselves? To which my response was, and I'm not sure the transcript extract is in the bundle that can be got to you, but my response was, if we are talking about the implementation errors that were part of their appeal, yes, you can correct those computational matters. If you are going to do something new and say that there was an entire basic error of approach and we will implement our own approach, my submission then was, and it remains today,
Yes.
that they should not.
But my question is whether it was on the cards, because if it was on the cards, then I'm not really understanding why none of the parties chose to refer to interdigital. The Court of Appeal can be criticised for not doing so when they, which was on the cards, did their own job on the evaluation.
Well, my lord, certainly from our side, where we were urging the Court of Appeal not to undertake it and said that it would be impermissible to do so, we were not in a position at that point to put forward evidence in relation to a matter which had not yet been articulated, because the Court of Appeal's decision and the reasoning supporting it, about which we have been debating for the last few days, was not available until the hand down. Sorry? Yes, and Mr. Nicholson points out, nor was it the other side's argument. that this is how things should be done. This was Lord Justice Burse's application, as he says, of the broad acts, which we saw operated when the judgment was handed down. And that is why we say that the criticism, to the extent it's made, is unfair. Now, ground 3 is, as my friend correctly says, the question whether, if we're right that the Court of Appeal, if the Court of Appeal was right, that the trial judge erred in principle for the reasons that we say he didn't, then should they have remitted or not? The point that was advanced, as I understood it, was that remittal should be if it's the last resort for doing justice. We cleave to the approach from the Iconics case that in circumstances where the trial judge's decision comprises a multifactorial evaluation in some sphere, and where the Court of Appeal does not have available to it the sea of evidence to make the assessment that it then proceeds to make, and in particular in this case, to give you one of the examples that I've raised before, it simply cannot tell by how much Apple's licenses are too high or too low, as it purports to do using effectively instinct. It should not proceed because there is a deficit of material. I fully accept my Lord Legate's point that if this court was satisfied that the necessary findings of fact had been made for the exercise that was then conducted, we would be in a different situation, because I would have no material within which to say that they should not have embarked upon that, and therefore justice was not done. So I accept that I'm essentially relying, in the event, on what I say was unfairness for all the reasons I've given for this argument. But I do say also that the starting point should be, with a multifactorial assessment, what one sees from the Iconics case. Now, ground 4, I will deal with briskly. Those are Mr. Abraham's 9 points and then the codicil. And then I would like, if I can, to say something about what occupied the argument for the entirety of yesterday afternoon, which was the submissions about the first instance judgment. So
You haven't said anything about the spread point.
Did I not?
No.
I'm sorry, that's...
Well, you said some things, but you didn't directly address the inference that the Court of Appeal made. You dispute that there was actually a pattern to the distribution, and it wasn't a random one, because you could see that the big companies got better deals than the small companies,
Yes,
and
that's
that
the point
justifies
I was going to make.
its approach, taking the big companies.
I'm extremely grateful that my lady points it out, because I had missed that part of my note and skipped on too quickly, so I'm going to deal with that because it's obviously important. The spread of values point. There are two issues to disentangle. The first is whether this spread of values is itself, as the Court of Appeal says, evidence of hold out, overturning the judge's conclusion, in effect. The second is how the Court of Appeal goes on to use the licenses, bearing in mind the spread of values. Here, I intend only to address the first of those. What light is shone on the question of holdout by reason of the spread of values? First point, it was debated with my friend that the larger licenses, a finding was made, involved the higher rates than the lower licenses. One goes to paragraph 122 on page 307 and looks 4 or 5 lines up from the bottom. The judge refers, to some extent casually, to 2 exceptions, and indeed there are more than 2 if one... I refer to Panasonic. Yes, so, there are more than... Certainly more than those 2. I will add in, for example, Panasonic. He refers explicitly to Huawei and LGE. These are major parties and major exceptions. And rather than therefore saying there's a trend, but there are these exceptions, in truth, and this was startling to my client, these are treated as exceptions that somehow do not disrupt the general rule. They are important in themselves, and they are explicable because what is in fact happening with the spread of values is something different from what the learned judge believed when he said all of these should be treated essentially as homogeneous, single licenses for cellular SEPs only. There are other factors, as the judge below appreciated, at play. Without going into them in enormous detail yet again, those include the following three: the hold-up capacity of a number of these parties. Refer again to our written case, paragraph 49, showing that in the currency of the negotiations for some of these very licenses there was this multiple litigation. The higher quality, potentially, of some of these portfolios of major licensors than the at-best average portfolio of Optis. And importantly, other value elements, not merely non-essential patents and so forth, but the wider business relationships. And you may recall in my opening, I took you to a confidential page showing the relationship with one particular major party, which was important to the outcome in that case. My friend took you to Miss Guttridge's expert report on this, that is Apple's witness, and I would ask you to open that again merely to read one of the following paragraphs which was not read on page 1543. That's it at the top, 6.52. 6.52 at the top of that page, where she echoes the submissions that I have just made, which were therefore also plainly in evidence before the judge.
I mean, it's curious because if the thinking is that the bigger the company, the more likely the rate is to be realistic, then you've got he ignores the biggest, which is Huawei.
Well, that's absolutely.
He includes Sysvol, which is one of the smallest.
Yes. My Lord, that's right. That's a development of my point, but exactly so. And that is why on this side of the courtroom, from the perspective of Apple, the exclusion by the judge of those two parties which he names, one of which is Huawei, the other is LG, as somehow not disrupting this trend, was startling, because it does disrupt it, and it tells you that the trend may not be correct. Yeah. And to conclude my point in relation to this, the Court of Appeal states that when one puts the patent-by-patent licensing practice, which, as I say, needs to be understood in the way that I've developed in my submissions, together with the spread of ranges, they say, and I quote, "There is only one hardly surprising conclusion," which is the artificial depression of the rates. It is sufficient for us to succeed on this alone that there are realistic explanations for the spread of values, which mean that the judge is wrong to say there is only one hardly surprising conclusion. If I may, in the remaining time, I've got 15 minutes, I shall go quickly through Mr. Abraham's ground 4, because I would like to try to say certain things in relation to the first instance judgment before we conclude for the day. So ground 4, I'll take his 9 points in turn and apologise in advance for taking this so briskly. Point 1, essentially, he said it's common ground that there are formally no limitation periods in this sphere, to which we respond. Formally, that is true, but in practice, for the reasons explained in our written case, this becomes a lever for obtaining back damages beyond the limitation period. And in this sphere too, the issue of recovery of recompense for past use of the patents is a real issue beyond the limitation period. That explains the industry practice which we appeal to. Second, Mr. Abrams says that a general release is given, yet payment is dating back only to the start of a limitation period, this industry practice. He says that end users will then be in scope as infringing, and he opened up a new argument which I had not heard before, though it was trailed by my friend Mr. Speck in his opening, that for this reason one needs to say that the limitation period is a false starting point, a false reference point, because you need to have a general release which will cover the private use of end users as well. Apple cannot be pursued itself for that private use, and my understanding, my friend Mr. Nicholson, is that personal private use is not generally an infringement either. The limitation period, ultimately, and it all comes to the same argument, is a pragmatic yardstick for negotiating parties to agree what will be paid in relation to licensing agreements, and simply arises in that context. Third, my friend says that Apple's submissions do not reflect ETSI's intentions, and then took you to a number of the documents. I'll refer only to a small number of those. First, the ETSI guide on financial contingency, paragraph 4.5. One reference is page 2374, I believe. Made my point already about this in opening, but it wasn't addressed.
Sorry, 1, 2, 3, 4.
2374. Which is that although there's a reference to making financial contingency, it is neutral as to how that financial contingency is to apply. It's consistent with the application or compliance with limitation periods. Next, page 2371, paragraph 3.1.2 of the ETSI guide. This is a paragraph which, so far as we're aware, has not been referred to in any previous court decision, or indeed prior to this hearing or these proceedings, except by Optis itself. All this refers to, if one reads it in full, is that the ETSI authors are warning that the ETSI online database has imperfections. You see from the first indent, ETSI hasn't checked the validity of the information nor the relevance, and it can't confirm or deny that these patents are in fact essential, potentially essential, hasn't carried out these IPR searches, and it's in that context that you get to the third indent, which says potential licensees should use the information in the database at their discretion and should contact the patent holder, for example, to establish the status of a disclosed patent. The English is clumsy, but what it appears to be saying in the context is that when you're in negotiations, because of the absence of the checks that we carry out, you are going to not, you must not assume that all of this is valid and infringed, it's there on the database. You will need, as the implementers, to contact the licensor. And it arises in that context. The same point applies to what my friend said about the capital letters front of the ETSI policy, page 2386. Lastly, he referred to the ETSI FAQs, frequently asked questions, on page 2374, which are gone and have been gone for a very long time. The only additional point to make is that he did not deal with the fact that, as this court found 6 years ago in Unwired Planet, ETSI looks to practice and procedure in the real world. And if that practice is, as we say it is, the industry practice, then that is of importance. Turning to the industry practice, his fourth point, he says that there's no finding of an established practice of limitation. He's right in what he says in relation to this case and the evidence. I've referred to Apple's evidence about what it does in this case, and he's correct to say that there was nothing about industry practice in this particular instance. The interdigital case itself is a different matter. In that case, there was such evidence about industry practice, and we say in our printed case that Lord Justice Arnold overlooked it. I think that's paragraph 127 on page 94. He dismissed reference to Samsung and ZTE, the recent decision of Mr. Justice Mead, saying Hollington and Hewthorne blocks one having regard to that. My submission is that it does not and it should not, and that is also clear indications of industry practice. And finally, you can take account of what the interveners say. It is not simply writ on water and worthless that they refer to the industry practice. It is a question of weight, and I refer to, where is it? This court's decision in E and Chief Constable of the Royal Ulster Constabulary, 2008, UKHL 66, which states where leave is given to such bodies to intervene and make submissions in the expectation that their fund of knowledge or particular point of view will enable them to provide the House with a more rounded picture than it would otherwise obtain. So it is for the court, I entirely accept, a matter of weight to attribute to it, but it is not worthless. And when 6 interveners come saying the same thing, it is important. Okay. My Lords, given the remaining time, subject to your views, I will spend the next 6 minutes or so on the first instance judgment rather than further points on ground 4.
Yes, certainly.
As I say, this part of the argument occupied the entire afternoon yesterday. Criticisms were made extensively of the trial judge and the trial judge's judgment. And before saying anything about those criticisms, I wish to distinguish 2 separate matters. The first is the judge's essential findings of fact, which occupy much of the first part of his judgment and which occupied, evidently, the vast majority of all the time at the trial. And those findings go to 2 essential matters that are the bedrock for the FRAND determination. The question, which licences are usable to help the court arrive at a FRAND rate in this case? And what is the strength of Optis's portfolio and its share of the overall stack? Those are 2 key matters. On the latter point, the strength of the portfolio and the share of the stack, the court knows there is no challenge by Optis to the findings in this appeal. Indeed, there's agreement that as the judge decided, the portfolio should be treated as at best average and Optis's share of the stack should be 0.38%. I refer you, I won't read it out now, to the draft consent order that was filed with this court, which sets out at paragraph 5 the parties' agreement not to revisit the first instance findings on these matters, including at any retrial or other remittal of issues in these proceedings if ordered. So the parties are agreed as to that. On the former point, which licenses, the judge made findings that are unchallenged concerning the worthlessness of the Optis licenses, putting to one side Optis Google, and he made findings that the Apple licenses, bar the anomalous one with a company called Qualcomm, where for specific reasons the rate paid by Apple was not competitively negotiated and was far too high to be FRAND, those were all competitively negotiated. And they disclosed license rates that could not be criticised, the judge found, as artificially depressed. So I come back to the starting point. That is a key finding the judge was entitled to make. And that is the subject matter of our ground 1B. All of the criticisms that were made yesterday over 2 hours went to a separate matter, which is, once the judge has decided which licenses are usable in the FRAND assessment, based on his review of the evidence, how does he go about the assessment? That's the logically subsequent question. And the heart of the criticisms yesterday, all of them, was the judge confuses basic terms, for example, referring to a lump sum rate, as I did myself inadvertently, when he should have said lump sum. He departed from common ground between the parties, and he propounded a method of his own, divorced from anything the parties had proposed without warning. All of these are ultimately points that arise if we succeed on our grounds in this court, and there is then a remittal. They affect the shape and the content of remittal. Now, having said that, although Mr. Speck was correct that the judge made various errors in certain paragraphs of his judgment, and I'm not going to go back through that at all, I don't have more than 3 minutes to do so, the essential criticisms that he made on a number of points were overblown and in material respects for this court wrong, and the court should be aware of those. I confine myself to a very short number of points in the remaining minutes. First point, he said that the methodology of the judge was unheralded. I referred in my opening to what Optis itself, in its submissions in closing, put to the judge. And I said that one of those methodologies was along very similar lines to what the judge himself ended up doing. Mr. Speck said rather quickly yesterday that this was an approach put forward by Apple with which he engaged because Apple distorted it by missing out some licenses. If the suggestion was that wasn't a valuation approach along the same lines as the judge, which Optis took up itself in its closing submissions, that is not right. I'll simply give you the references again, pages 1, 2, 9, 4 and following, which I referred to earlier. Second, he said a few times that the judge's approach was based on a special price to Apple, rather than, as this court had stipulated in Unwired Planet, a single price applicable to all. It was not. There was no special price to Apple. The judge was looking to set a price to Apple given its particular volume of sales. That was the parameter it was concerned with. And the judge made the common sense point: a licensee with 3 times the volume of sales of another should pay a correspondingly higher price, and that is all. Third, Mr. Speck referred to my point in opening about the judge's inclusion of Optis Google in his methodology being an oversight by the judge. And he says, well, it was put in deliberately. I agree, it was put in deliberately by the judge. It was not an accident. I did use the word oversight. If you recall, my point was not that the judge included it accidentally. It was a different one. It was that this oversight, or this mistake, was because the judge saw 2 large companies and he thought, well, Google is rather like Apple. And he forgot that in this particular area, Google doesn't sell phones to anything like the same extent as Apple does. The volume of sales is a fraction of it. That appears to be what's happened. And fourth, and this is important, he submitted to you that the judge himself regarded that license as relevant, as a comparable individually for assessing FRAND. And he referred you to the final sentence in the High Court judgment, page 592, paragraph 473A. And that was wrong, because that sub-paragraph was not the completion of the judge's reasoning. The judge goes on in the very next sub-paragraph to complete the reasoning and concludes that the Optis Google license produces an unpacked rate which is, in his words, indefensibly high. My Lords, I think I'm out of time in any event. I won't make any further points. Those are Apple submissions.
Well, as I indicated yesterday afternoon, we're very grateful to Council for their assistance. I don't know how we would deal with this otherwise. So thank you. You've given us a great deal to think about, and we will do our best and let you have a decision when we can.